Yep.
Okay, welcome.
So I will just start. And yes, if I have any questions, maybe a bit interactive, I'll ask you. And if not, I'll just, and if you want to stop me at any point also, you can.
I will
Any
do.
questions? So welcome everyone to this legal session. It's titled Securing and Protecting Your Intellectual Property. Now, I do always start my sessions with a disclaimer to say that this is just for informational purposes. So there's nothing binding between anyone who listens to this and myself. So don't take my advice, go to court and say I gave it to you and then get me in trouble. That's not what this is. So so if you do need legal advice, you know, you could book a session with me or go to another lawyer and actually have an actual sit down with regards to the legal aspect of things. So that's just my quick disclaimer. This isn't my first go for here, so I'm going to skip this about me parts. I'm an expert at the ABC session, so.
You are, but it's never hard to hear what you've been doing.
So what I've been doing lately, actually, I do want to say this.
Yes.
So if it looks like I'm reading, it is because I am. I'm reading my notes because what it is I'm currently working on 2 projects, which is a course and a book. Wow. So some of the content that I'm giving today is, you know, it's from those 2 projects. Oh. So if it sounds like I'm reading, it is because I am, because I've written my things down for the book and for the course, and this is going to be in there in some capacity. So don't think I'm just reading because I don't know what I'm doing. I'm reading because I've written my content. So yeah, so that's what I've been up to. I've been trying to write the book that I want to get out, write the course, and work on a few other projects while still working a 9 to 5 in a startup fintech company. So
wow.
Very heavy.
Wow. Very that's heavy. A lot as well, as long as being mum.
Yeah. So we do our best over here. We just thank God. So yes, for starters, securing and protecting your intellectual property. Right now we are in this day and age, and I say it and it just makes me sound really, really old because internet wasn't really that much of a thing when I was growing up. And it's just the information is just becoming easier and easier to access and distribute. So it makes it so much harder to safeguard your intellectual property from theft and copying. Everything is everywhere, especially on social media. So whether you're a startup or you're a multinational company or or international company, taking the steps to protect your intellectual property should be priority for your business. Don't take that for granted. So as all business owners will know, product development, it takes time and it takes money. You go from market research to fine tuning it and to finally developing the program. Sometimes it takes months, it takes years, tens of years, you know, decades for you to get there. So any product that I make as a business owner or you make as a business owner, if we're being truthful with ourselves, the aim of it is to recoup all our costs back. I want some form of money back on my time that I've spent on there and to make sure that my business is commercially successful. And I want to, because we're talking about IP, if I'm first in, who can I use as an example? McDonald's, for example, let's say, I don't know the dates in how all these things came about, but let's say McDonald's was the very first fast food chain that, you know, that was around. We now have Burger King, we've got KFC, we've got Wendy's, we've got so many of them. And a lot of them are able to do what they do because they saw what McDonald's did and they emulated that, they copied that. So McDonald's had to be first in the business, and they had to do things to protect their business because there's always going to be somebody coming after you doing the same thing. You're never going to be the first person to do something. And even if you are, you're never going to be the last because someone's going to see it and want to emulate it and copy it. So keep that in mind as well as business owners. And a lot of people, they don't, in doing that, they don't develop their things from scratch. And it goes in line with something my dad always says to me is learn from other people's mistakes. So I'm not learning I'm not learning it from scratch. So if you know that as a business owner, the smart thing for you to do is from the get-go, protect your business, protect the assets in your business that can make you, that can make you money. Because what happens is you've done all the grind, all the graft, someone comes along and they're like, oh, there's a template here. I could do this and I can do something else on top of it. So they'll just, emulate what you've already done. You don't have that much ground. That's why when they talk about when you're ready to be first in that space, you've got to come hard, basically. I think I'm waffling a lot at this point because I always try and get it out to people. Like, if you're going to be first in there, get in there, but get in there well. Start as you mean to go, basically. So I say all of that, but the good news is that you can protect key parts of your business. You can protect how it's made, how it works, what functions it performs. So these aspects are your intellectual property, and under UK law, there are several ways that you can protect that. So that was just for starters. What is intellectual property? Everyone's always, you hear it, but I feel like IP and intellectual property has become a buzzword for quite a lot of people. So what is it? So the term intellectual property refers to any unique asset you have as part of your business operations. So it can be anything from your logo to your packaging, to the, let's say you are food, to the content of the food, to the recipe. So remember that an idea alone doesn't qualify as intellectual property. Right. It has got to be something that you have created or utilized. And with that said, in the UK especially, I'm going to talk referencing UK because that's the law in which I deal with. There are 5 main types of intellectual properties.
Okay. 2
of them apply by default. So you don't actually have to take any action in order to benefit from those 2. So the 5 are designs, copyright, trademarks, patent, and trade secrets. So the 2 that apply by default, and you don't have to do anything to benefit from it, you just have to create the work. It's designs and copyright. So that's the first 2 on the screen, and that's what we're going to talk about first. Okay. So designs, this is the shape and the configuration of objects. And they have automatic protection for 15 years from the date of creation, or 10 years from the date of the first sale.
Okay.
So let's say, for example, you're trying to protect the design of a top or something like that. It's got to be extremely unique and whatnot. So from the time you created it, it's protected for 15 years. From the time you first sell it, it's 10 years. So this means that another company can't mimic your distinctive design as soon as you've released yours.
Okay.
So I've put it in the shop, I've stored it in Zara. That's why you have a lot of there was quite a few things. There's this company, Black owned, called Kai Collective, and I think she was in a battle with was it? I'm not sure if it was like all these. It was one of the fast fashion companies. I'm not sure if it was or Pretty Little Things. You know how they are. They'll see someone design something and they do like a cheaper version. So hers sell for like the hundreds. They were doing it for like £20. Wow. So I don't know if she won because I didn't follow. I didn't follow that particular case. But it's things like that. So I'm pretty sure she would have won because she was first there. She had designed it. She had released it. Note as well, actually, that design rights can be registered. So even though it's automatic, you can also register it if you choose to. And I always say choose to. The best thing to do is just have it on paper, choose to register everything you can. The second automatic right we have in the UK is copyright. So if you create original writing, content, art, photography, film, music, or sound recordings, you will likely be automatically protected by copyright law. So this means that you can take legal actions against anyone who tries to claim your creations as their own and use them for their own gain, basically. So for small businesses, I always say copyright applies to anything created by an employee during the course of them working for you. That's why if you look at most people's contracts, they always say anything you create in the process of working for me belongs to me.
Belongs to me.
Yeah. So if you, for example, as well, if you take your own photos for marketing campaigns, for example, they belong to you. I always like using photographers as examples, because if a wedding photographer was at my wedding and they took pictures, I don't own those pictures.
Yeah,
They do, because it's their work. Yeah. So it's things like that. So if you write all your web content, your blogs, that's your work, and it's protected by copyright. But speaking of things like blogs, I understand that as people who write content, we also get our inspiration from other people.
Yeah.
So you've got to remember that I'm telling you these things about how you can protect your IP, but it cuts both ways.
Yeah. Yeah.
So if you take a little too much inspiration from somebody else's creativity, you might find yourself at the receiving end of a legal challenge. So just because, oh, I saw this blog that I really like and they write the same thing as me, let me just take a bit of inspiration from that. Be smart how you go about doing it. Don't copy it, because the rule of if you go to court and you say, but I only copied 10% of what they wrote, that could be the most important 10%.
Would
and you will still be found infringing.
Would the, like, say you saw like a template of a blog post, like you said, used for your instance, and you take inspiration from it and you rewrite it in your own words so it's different. If the layout is still the same, not the actual design, but let's say it looks very similar, is that part of it as well, or is it just about the actual text that's involved?
If it can be proved that you copied the layout. I feel like layout is a bit harder, because the thing is, if you're writing a blog or story, most things are laid out the same, the beginning, middle, and end. It's very difficult to apply copyright to an introduction. I mean, we're all taught how to write like that. You write the introduction, then you write the middle part, then you write this and that. So layout will be very difficult to prove, especially if you've turned it into your own thing.
Yeah, I was thinking, you know, like we use Canva and things like that, where you might get a little blog and it's laid out in a certain way. You know, it's the same design, and I know you're going to come to designs. Oh, you've come to designs already. It's the same design, but everyone's put their own spin on it. Is there any? Can someone say, like, "Oh, that's Canva"?
No, especially if you got it off, especially if it can be proven that I got it off Canva. Because all the art that's on Canva and things, they've been released. In a sense that people have, they're copyright free. So if everybody's using it, everybody's using it. There's really nothing you can do. You can do so. Yeah, because I mean, I use Canva, and I'm pretty sure there's some designs that I've done that you can put it next to somebody else. You might have different content.
Yes.
But we can both look at it and be like, you use Canva, I use Canva. But as long as the content is different, and it wouldn't fall for design, right? Because it's not unique.
Yeah. Okay. Yeah. Because
so another aspect of the design is it's got to be unique.
Got to be unique.
That's the bit it's got to be unique. It's a template. If it's a template that everybody has used and it's royalty free, for example, it's copyright free, you can't claim it as yours.
Right. Okay. All right. That's good to know.
Yeah. So those are the two automatic rights, automatic IP rights, designs and copyright. The other three, trademarks, patents, and trade secrets, you have got to register them.
Right.
So trademarks, we're talking logos, images, slogans, and these things are very, very fundamental to brand recognition. It's how most people know a brand. So the logo, for sure, there's nowhere I would go in this world, well, maybe like not indigenous places, but you know what I mean, that you will see the logo of Louis Vuitton and not know it's Louis Vuitton. Or Chanel, or McDonald's. Let's use the one worldwide, McDonald's. There's no way you won't know. So if you trademark your unique business identifiers, it helps, protect the distinctive personality of your company. So all those things, they are identifiers for your company. As long as you can, if you identify something, you say, yes, this is unique to me and my brand, protect it straight. Even I don't care if you don't use it for the next 10 years. Own it, have it as yours, because the last thing you want is when you're now ready to use it, it's not available. So to get a trademark, you must be trying to protect something that's completely unique, that is not misleading. Which is why I say, if you're going to register a trademark, you can't, let's say you were selling sheep's wool, for example, I don't know why. You can't register a name that has cotton. It can't be a descriptive word for what you're selling.
Oh.
So Starbucks can't trademark coffee.
Yeah. Okay. Yeah.
So it can't be the name for what. That's why they always say one of the best ways to get a trademark, to actually have your mark registered, is to have a very unique name.
Yeah.
Sometimes names that have nothing to do with your business.
Right. Okay.
Because what it is when you're doing a trademark, the things that will identify your business are the categories you register in.
Right. Okay.
So my name can be XYZWQ for all they cared, but as long as my categories are what I do my business in,
right.
The name is supposed to be unique. It's supposed to be distinct. It's up to me as a brand to figure out how to tie that in for my customers.
Right.
So that's the thing. And I always say to people, you pay for this application, so do your due diligence.
Yeah.
Do your research. Don't register something off the cuff just because you want to secure something. So if you have, so that's trademark. Patent is the other one. So if you've invented something that's either completely new or performs a function in a new way.
Yes.
So there's that. So it's got to be completely new or performs a function in a new way. You can protect it through a patent. So this is what patents mostly apply to, things like machines and medicines. Patents are huge in the pharmaceutical industry. So all this, a lot of pharmaceuticals patent a lot of their drugs.
Yeah.
So all these drugs on the market, they're all patented. And it takes a while. So an application for patent typically takes 5 years. And it costs you thousands of pounds. It is not like a trademark that is a couple hundreds here and there. Patents are thousands of pounds.
And do they last for a set amount of time as well? Because I know with some pharmaceutical medicines, they have a patent for so long, and then the patent wears out, and then other people can start
but it's all dependent on what you're patenting.
Right.
So there isn't like a definite. I know if trademarks, most definitely. I know that one off the top of my head because that's the one I tend to deal with more. Right. That's 10 years. You've got to renew it in 10 years. Patents, I can't even get onto my Google because I was going to have a look. And just be like, let me see if I can get the answer for that, because it's 20 years.
Right. Okay.
Generally 20 years, but again, it depends. It depends on what you're registering, because when you look at, like, for example, we're talking pharmaceuticals. There's no way is it GSK? There's no way they're gonna let anything lapse for 20 years before they renew it. They are watching these things like a hawk. So patents, because they pay thousands of pounds for these things. And I find that a lot of small businesses, unless you're in the, let's say machinery or automobiles and cars and things, you're not really doing patents. Most small businesses are more trademarks and things along those lines. So the last one, the number 5 IP in the UK is trade secrets. So they're usually classified as confidential information, such as formulas or recipes. So you have recipes can be protected by trade secrets. And a lot of them are developed, because the thing is, the truth is, a lot of them are developed to create commercially valuable products. So I do know that one of my former clients that I did an NDA for, they made fish without using fish.
Vegan stuff. So
it's like, it's vegan stuff, but it tasted like fish. I've never tasted it because I'm not vegan and whatnot. But their thing is, it tasted like fish. You would think it was fish. Wow. So when they were looking for funding and sourcing things, they needed an NDA, because if that's the first time, and remember what she was telling me, I obviously don't want to say too much because it's their business, but she was saying that it's never, the way they did it has never been done.
Wow.
It was completely brand new. It was something they developed, never been done. So if they're having all this discussion to secure funding, they needed to protect it. That's why I drafted an NDA for them. So those kind of things will be protected by trade secrets.
Right.
Because it's a recipe. So generally, a trade secret needs to satisfy 3 conditions. It has to be a secret. That's a no-brainer. Number 1, it has got to be a secret. Number 2, the owner of the information, they have to show that they've taken reasonable steps to protect it.
Right. Yeah.
So if that's keeping your recipe in a lock and key in a vault,
Right.
just show reasonable steps that you try to protect it. And thirdly, you've got to show that there is a commercial value in keeping this information confidential. So if it gets out, is it going to ruin how you can make money or what you can gain from it? So those are the three things.
Okay.
Another thing actually is everyone, when we talk about IP, they don't always have to be for different things. They're for different things, but in your business, it doesn't have to. It can exist under one product. Basically, that's what I'm trying to say.
Right.
So the UK government will allow more than one protection to apply to one single asset. And I'll show you a grid. So that's it. So you've got a product and you've got different parts of the product. So the name and the logo can be protected by trademark.
Right.
The unique features of your product can be protected by patent. The design of your product can be protected either by design rights, the automatic one, or you can register it if you want to. The artwork and the copy, so the content of your product is automatically protected by copyright. And the recipe or the formula aspect of your product can be protected by trade secret.
Wow.
So you can have one asset. So I'm trying to think of, let's see if this example will work. Fanta.
Okay, go on.
Fanta has a very distinct shape in terms of the Fanta bottle.
Yeah.
Has a very distinct shape. So let's say Fanta, the name and the logo can be protected, even though they all come under the Coca-Cola company.
Yeah.
But the name and the logo can be trademarked. The unique feature can be patented. The design of it, so we're talking, for example, let's say the distinct design of like the bottle or the label or something like that can be protected by design rights. The content of the artwork, the way the picture is drawn, whatever, automatically copyrighted. And the recipe of how they make it
right.
Trademark, trade secrets. That's a very loose example because I don't think that would work for all of it, but it gets the illustration of what I'm trying to say out there. But so you can have one product and protect it with every single one of this intellectual property if you wanted to.
Wow.
Yeah. So tips to protecting your intellectual property. I have a few written down. First and foremost, keep your business ideas and trade secrets a secret. Learn to close your mouth. It's not everything you've got to tell. I keep telling people it's not everything you tell everyone. The idea, it's not everyone is going to be nice enough not to spill the secret or steal your ideas and whatnot. So until you have adequately secured your intellectual property, avoid talking about it to other people unless they've signed a non-disclosure agreement.
Wow. Okay.
So it's different. I mean, it's different if among true friends, I qualify that, among true friends, if you're having a discussion about some of your business ideas. But if you're in a networking meeting, for example, and you're spilling ideas of what you want to do, and somebody there's thinking, oh my goodness, if I do it this way, if I take that same idea and do it this way, I can actually do more. And they run off and they trademark it, they run off and they start doing it because you haven't done any of that.
Okay.
You've lost it. You have got to be careful who you trust with key information. And please, do not promote your ideas on any public forum. Stay off Twitter with that idea. Stay off Instagram. Right. It's not every time tell everybody you're working on this. Okay, if you want to entice people and say I'm working on a secret project, fine. But you don't need to tell people what the secret project is or the details. Exactly. And also, if you're working in a business with partners, if you're working in a partnership, speak to a lawyer and sign an NDA. So if you want to start a business and there's a few of you, if you don't already have a partnership agreement in place because it's not a done deal yet, or you're thinking of having discussions with people about how you can start, have an NDA, especially if the idea is going to be coming from you. And I think what also happens is if you have an NDA, it protects everybody because let's be fair, the other person, if they're coming and you're all sharing ideas and their idea is a bit better, it kind of, it helps everybody. But from your perspective, you're going to be sharing ideas that you have an NDA and whatnot. Number 2, document your concepts and original content in detail. So if if you make sure you have detailed drawings, descriptions, plans, records that can prove that you came up with and you've been working towards this intellectual property for a very, very long time. So, for example, if you're writing a book, keep your manuscripts, keep your drafts, like the very first draft that you've done. Keep all of those things, because what you don't want is for somebody to come and challenge you and say that they are the rightful owners. And if you can find a way to date them as well, that will help in any sort of challenges, because you know, if you make sure you've added dates wherever possible, first date of use is very critical. So the court would be like, you use it. So if we have the same idea, we're writing the same book, but for some reason I wrote my book in November 2020, and then you wrote yours and it came out December 2020, I have first use. And I can prove it because I've got my manuscript.
Even if you haven't protected it, even if you haven't protected it already.
Yep. Because it's a book, it's automatic protection, it's copyright. But right. I have first use because I've got evidence to say I wrote my draft in 1995 or whatever date or whatever date is on there and whatnot. Obviously, that's going to be difficult to prove because somebody can also come and falsify information and print something now and put another date on there. So there will be other tests, but this is just a way that you can help yourself if anything, you know, were to happen. So, for example, I always tell people business plans, they change over time, keep your old ones. So those kind of things. Anything you write, meeting notes that you have, meeting minutes, that's what I wanted to say. Keep those as well. Because in meetings, you talk about different stages of different ideas, don't you? So if you've got that written down, I can go to a meeting minute that was 5 years ago and be like, look, we actually discussed it first. Here. So any document that you can keep that has a bit of detail of what you're working towards, keep it. File it away somewhere. And we live in such a world now where everything is electronic, so you could scan it onto a USB or whatever it is and keep it that way. So that's number 2. Number three is apply for a trademark. As soon as you have a business name that you know you're going to stick to, a logo that you know you're going to stick to for your idea, register your trademark right away. Because the trademark costs money as well, I always tell people, make sure it's a name on the logo you want to stick with at least for the next 10 or so years. Because once you've registered it, you can't go back and edit. Once you've submitted your application, you can't go back and edit. It's done. So make sure but if you have money to blow, then you can keep registering different names at different points if that's what you want to do, but make sure it's a name you want to stick to or a logo you want to stick to and then register it. So for me, for example, my logo isn't trademarked, but that's only because it's just my company name. And there's nothing distinctive about it that is rushing me to trademark it. You can't use my name. So it's not really there's nothing distinctive or designed or any of the design that is really pushing me to get it trademarked. But my podcast name, that's trademarked. The name of my course and what I'm going to title my book, before I even told anybody I was thinking about doing it, I got that trademark straight away. So I can tell people now I have no problem saying it because I know I've got the trademark for it. And I'm going to keep renewing it because it's a name I really wanted. So much so I fought a law firm for the name. I registered it and they sent me a letter saying it's very similar to the name. So my the name I registered was Get Legally Set. Their name is Get Legal. So they sent me an email and said it's so similar. But then also in their letter that they sent me, they also mentioned that it's a name they hadn't used in a long time and they don't know when they're going to resume using it. So it wasn't like anything that had to go to court because I just ignored them as like, I don't have time. So this kind of, I responded my own way and whatnot. But the name meant so much to me that I didn't drop it. I fought for it and I got it. So if it means something to you, I would advise that you do the same before you start creating the work. I secured the name before I started writing the course.
Yeah.
Because there was a vision that I had in mind. And if I started doing it and I couldn't get the name, that would set me back.
Right. Okay,
I would have wasted time doing the things I wanted to do. So apply for a trademark as soon as you can.
Yeah, I think I have to have a word with Mary, I think.
Yeah. Oh, I did, exactly. Because the thing is, your trademark is what your business is known for.
Yeah.
So, I tell Mary all the time, because it costs money. Mary's always like, oh my God, this bill is racking up. I was like, yeah, but somebody will just come and take your name. And then you're going to be like, what is happening here?
Yeah.
So, So number 4 is know all your IP. A lot of people don't think they have intellectual property in their business, but it's not until they start talking to people that they realize that they do. So what I always advise people as a business is get an intellectual property audit done for your business. What assets do you have in your business? What different types of just the best thing for you to do is know what IP is in your business. You don't have to register every single thing, but just know what is in your business. Know the one you already have automatic rights to. Know the one you have to register, and then prioritize it.
Yeah.
Because it's not every single IP in your business that you have to register. For me, I see it as it depends on which one is more important to me and what I'm doing.
Yeah.
So for example, like I said, the example of my logo is not distinctive enough for me to say I'm going to register it. Because if somebody comes and wants to, they can't use, my logo is the name of my business. You can't use it because I've already protected the name.
Yeah.
So I'm not going to bother. I'm not going to bother trying to spend money registering that because it's just my business name that is already protected.
Right.
And it's just written in cursive. There are millions of different cursive ways out there that if I choose to change it, people probably won't notice I've changed it. So it's one of those things. But if yours is distinct, like I've said before, register it. So it's all about knowing the different IPs you have in your business and then prioritize how you want to deal with it. 1, 2, 3, 4, that was number 4. Number 5, prevent IP theft through contracts. So ensure that your employment contract or your consultancy contract or your internship contract, whatever contract you're giving that to people, ensure that it clearly states that you own the IP that's developed within the duration of them working with you. So I've employed you. Whatever you create in the 6 months, in the 1 year, in the 10 years, belongs to me, unless otherwise agreed or stated. That's what most employees do. Most employers do, because you've got to think about, I've employed you, so it's on my dime that you're creating this. So I basically own it.
Yeah.
And stuff. So prevent it through contracts. Let me going off the contract one, let's do this the other way around. So use an NDA to protect your confidential information. Another type of contract is an NDA. So using an NDA means that the person or the company you're working with has to keep shared information confidential. They only use shared information for the reasons you've shared it. So you can't go and talk outside of that. They can't disclose shared information to anyone without your permission, and they have to destroy or return the information at your request.
An NDA is non-disclosure agreement, yeah?
Non-disclosure agreement, yes. So for example, now my 9 to 5 is with a fintech company. Fintechs are so protective of like their information and how they work because it's in the banking sector, it's in the technology sector. So what we do, so every meeting we have, everything is spoken at such a surface level. If you want to go deeper, everyone's got to sign an NDA. The amount of NDAs I read and go through on a daily basis before we can have discussions. And we're not even signing a contract to work together. Like we might not go forward to working together, but everybody has to sign an NDA.
Wow.
So I'm always signing NDAs. I'll be okay, we need to have this discussion to see how our businesses can work together, sign an NDA. So you cannot talk above a surface level before you sign an NDA. So if companies are doing it, you as a small business, start that practice. I feel like everybody is doing a business for it to grow and to be something. So start as you need to go. Practice that now, writing an NDA. And an NDA doesn't always have to be a massive document either.
Right.
Just have the key things that need to be in there.
Mm.
and have the discussion with, you know, investors, for example.
Mm.
Investors are another one. If you're not careful, they could be dodgy. If your idea is good, they
Yeah.
will take it and run with it.
Yeah.
So do that. So, you know, consider using an NDA whenever you're giving information to a third party.
Mm.
So, like I said, potential investors, contractors, suppliers, or other businesses that you want to collaborate with. So, you know, an NDA, it helps discourage people from misusing your information. It can also make it easier for you to make a legal claim against them if they break the agreement.
Yeah. Yeah.
So if you share, So, and the thing is, if you, for example, using patents, because patents are so, like, patents are very, very high level. It's a very, very high level protection, right? So if you share information about a non-patented invention, for example, and you don't have an NDA, you could lose the right to patent your idea. Because remember, I said a patent can only protect an idea that's new or doing something in a new way.
Right.
So if I've already disclosed it, it's no longer new anymore.
Is there ever an opportunity where you might want to use an NDA and then the second or third party says, no, I don't want to sign it?
Oh, then don't discuss it with them.
Right, okay.
But most businesses, if you're serious enough to want to do a business, you sign an NDA, because all the NDA is basically saying is we can have a discussion, we can have an open discussion, knowing full well no one is going to go and spill our secrets. Yeah. If you're not willing to sign an NDA, I cannot trust you. Because clearly what you're saying to me is, I want to hear your idea, and if I like it, I might run with it.
Yeah. It also shows that you're kind of taking your business seriously, doesn't it? If you can put that in place and make sure that you're covered. Yeah, no, there's some good points there. Yeah,
because if you say no, in my 9 to 5, if you say you're not signing an NDA, I can't work with you. I'm so sorry. Yeah. I don't trust you. I can't work with you. And the other one, the last one, is protect your IP early. Registration can take time. Like I said, registering a patent in the UK can take up to 5 years. A trademark can, be anything from 3 months to 6 months. A very straightforward, linear, not complicated trademark in the UK takes up to 3 or so months. And that's a very basic, straightforward one that has nothing, because what happens is once you've registered, you've got to wait a couple of weeks for them to get back to you. That could be anything from up to 4 weeks, depending on how busy they are, for them to get back to you. Once they've accepted your registration, it's got to be on a public journal, the IPO journal, for 2 months.
Oh, okay.
So it's got to be public knowledge that you've registered and it's been accepted for 2 months, because anybody who wants to oppose it, that's their window of opportunity. They give them the 2 month window of opportunity to oppose it. And if they, and then you can go, at that point, you can go, this is what happened to me. At that 2 month window, you can go back and forth with whoever wants to oppose it. You can then come to an agreement if you want, or, you can forget it and this and that. Before the 2 months is over, the other party has to decide if they're going to file or formal opposition. If they do, your trademark remains on that register for an extra month.
Right, okay. So do you automatically get contacted then if yours is very similar to someone else's?
Yes. So what happens is, when you're registering a trademark, if the Intellectual Property Office thinks it's very similar to somebody else's, they have an obligation to notify them.
Right, so that's how you'd find out.
So they'll notify them.
Right.
But then what also happens is, if you have the manpower to do it, you can monitor the journals. So the alerts that if somebody, you can set up alerts basically and put keywords in. So if somebody registers, if a trademark comes onto the journal that has the keywords I've set up an alert for, I will get notified.
Right, okay.
Then I would know somebody has put these 3 words together, or somebody has registered anything with the word legally inside. So I will always get a notification of that registration, and then I can have a look through it and be like, nah, this doesn't affect me. This doesn't, oh wait, actually this is pretty similar. Let me get in contact with them and have a conversation. So
what would happen if someone had, let's say, Shireen Torrance Dodd, just for example, let's say I've got a name, Shireen Torrance Dodd, I trademark it, it's done, and then someone else thinks I'm going to use Shireen Torrance Dodd, but I'm not going to trademark it. Can they still operate without me, if I didn't know they existed and they were doing their thing, and would they still, would it naturally fall out, or would I came across them, would it be like, oh, now we've got a problem? Is it only an issue if you both try to register?
No, it's if you're unaware of it, then there's nothing you can do about it. So they can keep doing their thing and you keep doing yours. Nobody knows about each other. If it then comes to your attention, let's say, for example, you're working in the same industry or anything, and it comes to your attention, then you're aware, okay, hang on, I've got this registered, but somebody else is using it. Let me check in with them and see what they're using it for. And then it could be a case of, please stop using it.
Right.
Or then you can go to litigation, for example.
Right. Okay.
But most times it becomes you would usually know if they now try to register, and then you will get notified that someone's trying to register it.
That's yeah.
But there's something to also keep in mind is you can have the same names, and it can the same names can be registered to different companies if they're in different industries.
Yeah, I've heard that before. But
so
then
sorry, go ahead.
They had that big case with was it WWF, Worldwide Wrestling, and Worldwide Nature Fund, and they were completely two different.
I think so. Yeah. And that's the thing, and that's what makes it.
Yeah.
And that's what makes it very difficult, because some people want to monopolize it, but you can't monopolize the name if I am in medicine and you are in alcohol. Like, you can't monopolize the name. Like, so you're not allowed to. That's the one thing that they try to do. The IPO tries to make sure that you don't monopolize a name. You give people room to also use what they want to use. So if somebody tries to register, get legally set, which is my name, but they register it, I don't know, for medicine, for example, that won't make sense because it's get legally set. So I could always argue it. But if it was like a name that didn't have anything legal inside, it was just a very random name or something, and with different industries, I can't really fight that if we're not registered in any of the same categories.
Okay. So like you said, as long as
so the whole thing about the registration is that it doesn't cause confusion for the consumers. That's it. As long as the consumer isn't really confused, that's fine. Because if they go on your page and they see clothes, that's one thing. If they go on your page and they see animals, two different things. There's no way a consumer can be confused by that. So that's that. But getting there early is always my thing for different reasons. Some of them take time. And sometimes it's best to be first in there. Because then you're operating on not really the defense. You're not trying to prove anything. You're already there, like, I've got it, so you need to prove to me. So the burden of proof is not on you because you're first in. I have the protection.
Just the strength.
So, that is definitely a strength. And the last thing that I wanted to touch on is how you fight theft of IP or infringement or anything like that. There isn't really much you can do in terms of fighting, but three things that I like to say, from like the softest thing to the most aggressive thing that you can do. Reach out and speak to them. So if it's a thing, if it's an Instagram or anything like that, or an email and things, just reach out to them and basically say, look, I noticed you're using this and you're doing this, stop, blah, 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 this and that. If they're refusing, you go to a lawyer and you get a cease and desist. It's the letter that basically says stop now, or it's going to become a thing. If they refuse to stop, that cease and desist becomes a formal notification that you can take it to litigation. And if they're still refusing to stop, you weigh up whether it's very, very detrimental to your business. Are you losing a lot of money? Will you lose a lot of money in the future? And do you have money for litigation? So you weigh all that up and then you can take it to court. So that's it. Quite a lot of people, if people are decent, you would think they will stop at the point of at least cease and desist. Because people try to fight the whole reaching out, like, who are you talking to? No, I'm not doing that. But at least at the point of cease and desist, you would think people will have enough sense to say, okay, I get it, and this and that. Once you kind of threaten them with a legal letter. But if it's going to be, like I said, extremely detrimental to you, you're losing tens of thousands, like your customers are extremely confused. I say you have the same brand name, same industry, but their customer service is poor. So the real business who has good customer service is losing out because people keep going to that
to theirs,
business.
reputation.
Then So you've got to really sit down with the lawyer and have a look at whether it's worth going to litigation, because that does cost money as well in the long run.
Yeah, it's a good amount to think about there.
So that's it.
Yeah, that's brilliant.
And that's how you can secure and protect your intellectual property.
Thank you so much. It's funny because it's one of those things that's a little bit not scary, because I've heard of trademarks and copyright and stuff, but I suppose taking that step to do it formally, it can be a bit, oh, I don't know what to do, or maybe it just sounds super expensive, like, oh no, I can't afford to do that, I'm not going to do it. But it's worthwhile doing if you've got something that you really believe in.
It's worth making the investment. That's another tip that I should have added in there. Make the investment, because it's all about what it's going to cost you in the long run. I would rather, because depending on, let's stick with trademarks, for example, because I say patents can cost you thousands and thousands, and not many people patent to start with. You've got to be in a specific industry to really go after patents. So trademarks, for example, it is expensive, but it's not as expensive as people think it is. It's what, £200 for one, 170 or £200 for one.
Okay, that's a lot more reasonable.
Exactly. So people make it think like it. When it adds up is how many categories you want to add. Because let's say you're paying £200 for the mark and one category. If you now want additional categories, it's £50 for every single additional category. So that's where it adds up. It adds up when you want to keep adding different things. So it adds up when you want to keep adding different things. So if you want to do clothing, if you want to do consultancy, all these things, some of these things are different categories. So £50 for each one, that's where the money adds up. So sometimes it's about, for example, when I registered Get Legally Set, that cost me just slightly over £400. Because I registered it in different things. So I wanted to do a course with it, so I had to register it in like educational or know those things. But eventually, and that's the thing about trademarks, and this is why it costs money, you think ahead, because you can't revisit to change it or to add on to it. You've got to think ahead. So for me, I would love to do merchandise. Like if the business becomes big and the course becomes big, I would want to have a shirt, I want to have a mug, a pen. I had to register in those
all of that now,
because my trademark lasts for 10 years. So in between 10 years, I can have merchandise if I wanted to with that name. So that's where it adds up.
After 10 years, you just renew it. Can you add anything on at that point, or does it have to be what you started off at the beginning? Really? Wow.
No.
Okay.
You're just renewing what you already have. So
that little bit of business planning then goes a long way. Something like that.
Yes. So that's when the trademark adds up. But I always then say on the flip side, it cost me money. And I remember I looked at it, I was like, oh God. But I paid that, but it's much better than, let's say I had done the course, I had used the name, I had been selling, I've been doing well. And then this law firm that tried to comfort me when I registered it, then came. And then I couldn't win. That's it. That's my course done. That's it. Like I'd have to go back to the drawing board. I've got to, like, people who knew me for that particular name and that course, that's it done. That's that brand over with. I've got to go back to the drawing board, and that's going to cost me so much money because imagine if you have merchandise and you have stock with that name, and I have hundreds of mugs or a notebook, hundreds of notebooks and pens that I'm selling somewhere that has that name. I can't use that anymore.
Can you get business insurance that covers you for things like that?
I haven't looked into that. I'm
pretty sure
you can. I'm pretty sure you can, but I don't think you'd be able to get business insurance specific for that. But I'm sure, like, if you spoke to like a tax accountant, there's always going to be a way. Where or like you speak to the insurer, there's always going to be a way where you can claim it. Come on, anybody who does accounting and taxes, there's always a way you claim something for something that
You're right.
So I'm sure there's a way you can probably pay a premium to cover it. But it won't fall under trademark. It'll probably fall under some form of expense.
Okay. Like a loss of business due to
loss of business. That's what it fall into.
Okay, that's really good. That's been really like tipping in. I hear IP and I'm like, woo, But
Yeah.
actually, how you've explained it
It's
and what
not
I've
as
written
scary
down,
as people think it is.
yeah, and it's interesting because people think often of patents and stuff, which are for huge
Yeah.
companies. But as a small business owner, self-employed, just getting your business started, I think a trademark is for your name and for what you're producing
Yes.
is good,
Yeah.
especially if you spend a lot of time on the website design, the logo,
Yeah.
the blah, the this and the that and the other of the
Most
website.
definitely.
Yeah. Yeah, no, that's really
Yeah.
good. Well, I'm hoping that this will be of great use to all of our members and everyone else that gets to listen, because, you know, we're all out there, and some of this, I know how hard it is being out there on your own, trying to do everything on yourself, how soul destroying it must be to have someone come and whoomp, or even
Rip
not
that
realizing that you're
completely.
trading in someone else's name without even realizing,
Yeah.
and then whoomp.
Yeah.
You know, it can go both ways. So I think that's really, really helpful. And the more legal stuff, the protection, sometimes it's, you know, we need the preventative measures and not always, you know.
And a lot of people don't take the legal thing seriously, not because I don't think legal is serious, but because everybody always has this thing of it won't happen to me.
Yeah.
But I always like, it won't happen to you until it does.
Yeah.
So
until you're in it. Yeah.
Like you said, yeah, preventative measures. That's what the legal protection is. Preventative measures. That's just it.
And, like
I would rather do that than find myself having to start all over again.
Yeah, protect and secure. And I think that's a really good way that you started it. Protection and security, because that's your long term. You know, now you're good to go for your 10 years now in what you're doing. Oh, that's really, really good. And I wish you all the best. How far are you with your book course?
The course, I'm okay. I'm getting there. I'm probably like halfway in terms of content with the course, because because obviously other priorities I have to keep pushing back. Which is why I haven't mentioned it to anyone, because I'm just like, I'm not going to start putting it out there until the content is done. Yeah, and then I can start working on all of the other bits, and I can, you know, keep telling, and I can put a definite dates and stuff. But the book is likely going to be end of the year towards next year, just because of I'm trying to take everything. I'm looking at it, and I was like, I should have gotten a ghostwriter.
Next time. Next time.
I was like, next time I'm gonna get a ghostwriter.
Well, good. Congratulations for just having the aspiration to provide something that's lasting and to share what you're doing. So I think that's brilliant. Really, really good. Really good. Well, I want to thank you.
Thanks
really, really good to have you on board. Yeah, it's lovely to see you again. And we're sharing this webinar on the website. So we'll get it on our YouTube channel, and then we'll put it on the website for all our members to jump on.
And everyone has my contacts anyway, so if they have any questions or want to book a discovery call, they can just
Yeah, and we're gearing up to our first anniversary for ABC.
Yes.
So we're going to do a global conference for Black coaches. So we'll invite you along to that if you're free. That'd be really good. Yeah,
definitely.
Okay. All right. Well, thank you so much, Aya. It's been a pleasure.
Thanks for having me.
You're more than welcome. You're more than welcome.
All right.